My name is Emma Snape, Special Event and Program Manager for the Maltz Museum of Jewish Heritage. On behalf of everyone at the museum, welcome to our virtual program, Scales of Justice, Jewish Justices and the Death Penalty with Marge Koosed. This program is inspired by our newest special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, presented locally by PNC Bank. There will be time for a Q&A at the end of the program. If you have any questions you'd like to ask Marge, please send them in the chat to all panelists or through the Q&A feature at the bottom of your Zoom window, and I'll compile them to ask Marge. I want to thank PNC and all of our sponsors and partners, including today's programming partners, Cincinnati's Holocaust and Humanities Center, Ohioans to Stop Executions, and the ACLU of Ohio, who all make it possible to bring a first of its kind exhibition like this one to Cleveland. The exhibition is open now, and we're currently welcoming visitors to join us safely in person, Wednesday through Sunday from 10 a.m. to 5 p.m. And of course, we also welcome you to explore the Notorious RBG from the comfort of home. In addition to the virtual programs that we're offering, on the first and third Tuesday of the month at 2 p.m., we're also offering a virtual online tour of the exhibit. Or you can bring a group for a private online experience. Whichever way you would prefer to connect with us, you can learn more at our website, www.maltzmuseum.org. I'm so glad you've already connected with us today, that you're here now as part of the Scales of Justice series, examining questions of ethics and jurisprudence, followed by audience Q&A. In today's program, Marge Koosed, Professor Emerita at the University of Akron School of Law and Board Chair of Ohioans to Stop Executions, will discuss the perspectives of Jewish Supreme Court justices on the death penalty, and will also touch on the debate over the death penalty in Ohio today. Before we get started, let me just introduce Professor Emeritus Marge Koosed to you. Excuse me for my goof there. Marjorie M. Koosed is the Aileen McMurray Trusler Professor Emerita at the University of Akron School of Law. Her writing focuses on death penalty litigation issues. She has taught criminal law, constitutional criminal procedure, and seminars in criminal process and capital punishment litigation. A member of the Akron Law faculty since 1974, she served initially as coordinator of the Appellate Review Office and Legal Clinical Program. She was the first female teaching faculty member to be tenured and is the longest serving faculty member at the law school. Her bar admissions include the U.S. Supreme Court, the U.S. Court of Appeals for the Sixth Circuit, the U.S. District Courts for the Northern and Southern Districts of Ohio, and the state of Ohio. Professor Emerita Koosed is a member of the American Bar Association, the Ohio State Bar Association, the National Association of Criminal Defense Lawyers, and other professional associations. She has also served as a member of the Executive Committee of the Association of American Law Schools section on criminal justice, and as an acting judge of the South Euclid Municipal Court. She served 2 four-year terms as a commissioner on the State Public Defender Commission, appointed by Governor Richard Celeste, and chaired the State Public Defenders Commission's Committee on Capital Defense Counsel Qualifications. She also served on the American Bar Association's Ohio Death Penalty Assessment Team, was an informal resource person for the Ohio Supreme Court's Joint Task Force on the Death Penalty, previously served as coordinator of the Ohio Death Penalty Task Force, and presently serves as board chair of the nonprofit Ohioans to Stop Executions. I can't think of anybody more qualified to give this talk today. And without any further ado, please join me in welcoming Marge Koosed to the stage tonight. Thank you, Marge.
I really appreciate the opportunity to speak to all of you. And Emma, thank you for everything you've done to put this all together. It's wonderful having the opportunity to talk about Justice Ginsburg and a little bit about Justice Goldberg, and generally to discuss views on the death penalty shared by Jewish justices. So without further ado, we can get started. And Will, if you'd like to move to the next screen, we can start the PowerPoint. I am privileged to have had times with both Justice Ginsburg and Justice Arthur Goldberg. And there'll be times for me to discuss that as we get into this further. I have a picture here of Justice Ginsburg in her chambers, and that's as I remember her. I was fortunate enough to be invited to her chambers in December of 1997. This was, and you can go on to the next slide, before the Supreme Icon edition of Ruth Bader Ginsburg, but she was all that too, just later. And in 1997, when I met her, it was because we had been engaged in some correspondence. I was trying to enlist her to come to the law school at Akron as a jurist in residence or a speaker. And if you go to the next slide, well, thank you. Basically, I took a number of students over the years to the Supreme Court for arguments. And one year in 1996, I did take a group of students to hear an Ohio case involving the Fourth Amendment search and seizure. And Ruth had taken a position of believing that although it was a very good rule that Ohio had developed to notify citizens of their right to refuse consent to search a car, that it wasn't constitutionally necessary. But she really liked the rule and was hoping that it would be maintained even when it was said to not be constitutionally necessary. And I wrote her and told her that I would be helping the lawyers out in that case to convince the Ohio Supreme Court to mandate the rule that they had started with. And as you can see, she dropped me a note with a signed copy of the opinion. The orange tab went to her concurrence. And the note said, appreciating your uplifting letter. That was very sweet of her. And she signed it. So I've treasured that. I didn't have much of an opportunity to talk with her other than 10, 15 minutes. The next slide, please. But we did end up having a number of things in common. One of them was, as soon as I entered her chambers, I was confronted with this lithograph. And the odd thing was that I had just purchased the same lithograph for my sister just a couple of months before. I noticed that while my sister's copy, I think, is number 50 out of 200, Ruth had the number 1. And that was because it's a picture of that was developed for rededicating the temple, the Sephardic synagogue in St. Thomas in the U.S. Virgin Islands. Maybe some of you, like me, have been there with the sand floor and such. And here she had been the individual that rededicated it following Hurricane Marilyn 2 years before. So I felt right at home, right at home. And I've always thought it's symbolic that there were 9 stars in that firmament there of the synagogue. And I've always thought of that as the 9 justices. We got a chance to talk about the interesting features of being a starting off woman and teaching at law school. She, of course, many years before me, but even so, when she talked about having just 9 female students in her Harvard class of 500, at Case Western, where I went, it was just 7% of the class was women in 1971. So we had a good deal to commiserate. And unfortunately, I was never able to convince her to come. But we did share a lot of viewpoints with one another, and some of those we'll be talking about today. Can you move to the next slide, please? So my question here was, how would Jewish justices, RBG and others, approach the death penalty? And it's simple in some respects and more complex in a few ways. RBG wrote the introduction to this Jewish Justices of the Supreme Court Revisited, and wrote that justice, justice shalt thou pursue is the strand that ties Jewish justices together. And I have to say, I agree with her. There is that demand in the Torah, and it is something that they seriously pursue. Next slide, please. And in fact, she ended up quoting Justice Goldberg, who I got to know very, very well, and he served as a treasured mentor for me and hundreds of other people. And he stated, my concern for justice, for peace, for enlightenment, all stem from my heritage. And Justice Goldberg's pictured there with me from 1989 or so. Next slide. He was a jurist in residence at the University of Akron Law School from 1984 and 1989. And this entailed him coming 3 days a week to teach over the length of the semester a Supreme Court seminar, which was fabulous. It was just wonderful for the students. And we all truly enjoyed having time with him. I became his occasional driver, his purveyor of Jewish foods that he missed because his darling Dorothy was not able to cook for him 3 days a week. And many stories I can tell at a later point. Perhaps we'll have time in the Q&A about how wonderful a person he was. But we'll focus on his viewpoints on the death penalty and those of others as we go forward. So before we get to that, individual justices, let's just take a moment, next slide please, to identify that we're going to be talking about the heritage of Judaism, the death penalty, and abolition efforts. And first, starting with the heritage of Judaism, in the next slide, you have a companion piece of the Torah and the Talmud. The next slide, please, Will. And some people have described this as being of two minds but one heart. It is interesting that there's so many diversions from one another, but at the same time, some consistency here. In the Torah, we of course have Leviticus's eye for an eye as a limitation on punishment, and it appears to be that, not a justification for it. So the penalty should be proportionate to the crime committed. But at the same time, while they had death eligibility for homicide, which would be the life for life, there was also death penalty eligibility in the Torah for breaking Shabbat and for disrespecting our parents, not things that we probably would think of as deserving of that kind of penalty today. Did have the ability to instill fear into witnesses who've testified falsely, because there was a great deal of concern about that, and that too was a death penalty offense. Basically, deterrence, retribution, and the preservation of the social fabric were what the Torah seemed to focus on. But in addition to being pretty strict about penalties, there was a demand for accuracy, for fairness, and an encouragement of repentance. In the Talmud, we get more depth. And in the Talmud, if you executed more than one person in 70 years, it was said to be a murderous Sanhedrin court. So it was to be a very rare and infrequent thing. And indeed, to assure that there were no mistakes made, they required two simultaneous eyewitnesses to the crime who saw the crime, who also saw each other, and had the time to and did warn the assailant before the act. And if you break that down, they're talking about assuring reliability, that we have an accurate identification of who committed this crime. We're assuring that there was a crime, and we're assuring that the person had time to think about whether or not, and was warned whether or not they should go forward. So they had some form of criminal intent, some mens rea, as we call it in the law. If those circumstances were not met in any case, then murder could only lead to imprisonment. And it did, through the Talmud, encourage mercy and second chances. In fact, I've often thought that Sister Helen Prejean and Brian Stevenson's viewpoint that each of us is more than the worst thing we ever did, which I find to be totally true, it fits here. They would have been very much at home in the Talmud with rabbis. But the concerns that they were identifying in the Talmud and the Torah are still with us 2,000 plus years later, as we consider in Ohio whether to repeal the death penalty. The Ohio death penalty was enacted that we're currently working on just almost 40 years ago now. And it is the subject and has been the subject of extensive concern. And this year in the legislature, there's strong bipartisan support for two bills that would repeal the death penalty prospectively, HB 103 and SB 183. Excuse me, I think I have those wrong. HB 183 and SB 103 are the numbers. Sorry about that. But we will be discussing why the effort to repeal is underway and what has been going on around the country, as well as what's been happening in the court. We can go on to the next slide. As we get into this, think about the disabilities that the Supreme Court operates under. They're not in a position to prescribe every aspect of capital punishment litigation in one all-encompassing decision. They're dependent on the cases that come to them, and they're deciding these issues on a case-by-case, factual situation by factual situation. And the law, therefore, evolves very slowly. And justices have, over the years, been tinkering a lot with the death penalty to try and make it better. But the question of whether it can be fixed at all is the question that everyone is dealing with now. And increasingly, I and others are coming to the conclusion it simply can't be fixed. It's broken. But we'll discuss how that came about. So let's go on to the individual justices. Can we go on to the next slide? Louis Brandeis. Some of you may have heard his name. She served for 23 years during a period when, not unexpectedly, some anti-Semitism arose respecting his nomination. But he was a Renaissance justice, the best lawyer in the country, and was indeed appointed to the court. In terms of capital cases, he reversed the Scottsboro Boys' conviction and death sentences in Powell versus Alabama. Many of you may have heard the story of the Scottsboro Boys. These were 9 feeble-minded, as the court pointed out, and indigent and illiterate individuals, Black African Americans, who were taken off a train in Alabama on the allegations that they had assaulted 2 white women in the compartment or in the carriage with them. Those claims were false, and indeed they were pardoned later. But the Scottsboro Boys decision was a very important one because it did ensure the right to effective assistance of counsel in capital cases, and thereby the right to have rights, because without a lawyer, you're not in any position to actually defend yourself effectively. So this was a watershed ruling, and he joined it. He didn't write it, but Brandeis was very helpful in establishing that right to have rights. He also, probably you're aware, was very engrossed in the right to be left alone and many of the privacy cases that we have. And for that matter, government accountability cases that we have flow from him. He was the first to state that when the government breaks the law, it breeds contempt for the law, and the importance of holding the government accountable. The other part of Brandeis's heritage to us is establishing the Brandeis brief practice. And this was done when he was a lawyer litigating before the court, before joining it. He would take objective data, and was the first to do so, and intensely scientific approach to arguing your case and putting all the objective data together to support his arguments. And the Brandeis brief is the most common practice these days, especially in Eighth Amendment, cruel and unusual punishment, capital punishment related litigation, because the evolving standards of decency that we use as the analysis under the Eighth Amendment of whether something is or is not cruel and unusual as a punishment depends on seeing what jurors, judges, governors, legislators, and others, and even other countries, treaties, obligations, and constitutions may do with respect to that level of punishment. So the evolving standards of decency depends on objective data, and we use Brandeis briefs all the time to establish those arguments. We can go on to the next slide. Justice Felix Frankfurter. Before he joined the court, he was a Harvard law professor and wrote a book about the Sacco and Vanzetti capital cases prosecution, and the feeling that they had been unfairly prosecuted and sentenced to death due to anti-immigration and outsiders bias, something he understood well. He believed in many respects that the Jewish community was amongst those that were outsiders. He also helped found the ACLU, and he was a lifelong opponent of capital punishment, which came through in some of his cases, but not in a let's abolish the death penalty sort of way. He was very much in the judicial restraint vein of members of the court. And unless a practice shocked the conscience of the community, it was so unfair that it could not be imagined in a civilized society that this matter would have happened. Unless you fit that shock the conscience, test, you didn't have a violation of due process that would entitle you to a retrial or a rehearing of your case. So in a couple of cases, Columbia versus Connecticut, he wrote a concurrence about an intellectually disabled man of mental age of 9 who was over 5 days forced interrogation, gave a confession, and found that to be shocking and indeed unreliable evidence. In another case, there was a racist provocation, and he believed that the death penalty was not deserving in that case. He also had objections to the Irving and Ethel Rosenberg's prosecution and death sentences. And interestingly, in Trop versus Dulles, he dissented. That case had held that the Eighth Amendment would bar loss of citizenship for a military type violation. And he felt that that didn't compare to the mental torture of the death penalty or the physical loss of life. But again, that was in dissent. And his practice of judicial restraint was well honed. Interestingly, he hired the first African-American law clerk, but then when RBG in 1959, being first in her class at Columbia, applied for a clerkship, he rejected her. So Felix wasn't perfect, but he was good. Next slide, please. Now, Justice Arthur Goldberg, I think of as perfect, but that's my personal viewpoint. He served 1962 to 1965. Some of you may remember he was Secretary of Labor under President Kennedy, and later when LBJ wanted his help in negotiating an end to the Vietnam conflict, he became the UN ambassador and retired from the court. He's best known for Griswold versus Connecticut, which is the case that assured that married couples would have access to contraceptives and led to the right to privacy being acknowledged, that led to eventually Roe versus Wade. He was indeed, as one writer put it, an ardent feminist married to an ardent feminist. And I have to agree with that. There were times when we met for lunch in DC, and he insisted that we go to a club that discriminated against women being members because he wanted to break them of that practice. So every time he went to the club, he had a woman guest with him, and eventually they did. So I'm glad I was able to help out on that. But in terms of the death penalty, he actually is the originator of most of the arguments that we have today surrounding use of the death penalty. His dissent from the denial of certiorari, the refusal to hear a case in Rudolph versus Alabama in 1963, put out a roadmap of what was constitutionally amiss with the death penalty under the Eighth Amendment and under the Equal Protection Clause because of its discriminatory and arbitrary application. And from 1963 onward until 1976, we did not have executions. There was a moratorium brought about largely by his denial of cert and litigation over that, and the efforts that he made in a Harvard Law Review article to put together the arguments for why the Eighth Amendment and the 14th Amendment foreclosed application of the death penalty, ultimately leading to the Furman decision that did abolish the death penalty under the practices then used in 1972. So that roadmap is still the roadmap we use today, even though the court reaffirmed the possibility of a constitutionally systematic use of the death penalty in 1976. There have been narrowings of eligibility for the death penalty under the arguments that Justice Goldberg had made. So we no longer can execute juveniles or the intellectually disabled or persons who have committed some crime other than murder, or executed anyone who did not intend to kill or attempt to kill someone. So his focus on disproportionality of punishment, and indeed on the lack of necessity for the death penalty, that a less severe penalty like life without parole is adequate to meet penological goals, are part of the framework that we still work with today. And it was one of the reasons why he and I got to know one another quite well, and why I tried, as others have, to carry on his work. Next slide, please. Justice Abe Fortis took over for Justice Goldberg Before he was appointed to the court, he had argued Gideon versus Wainwright, the fundamental watershed case that assured, once again, the counsel would be available to those persons who could not afford it in any criminal prosecution, in fact, felony or even some misdemeanors. He was on the court during the moratorium period I mentioned, so he didn't really have an opportunity to rule much on death penalty cases. But after leaving the court in 1977, after the court had reaffirmed the possibility of constitutionally permissible death sentencing, he wrote a piece for the New York Times, The Case Against the Death Penalty. And that in turn has been a roadmap for abolitionists, for state courts and state legislatures to work on whether they wish to have the death penalty or not. And so his influence came before and after his time on the court. Next slide, please. Now, Ruth. Ruth served for 27 years, so longer than any of the other previous justices we've related. And on a personal level, we know what she would do with the death penalty. She would be supporting repeal in Ohio and, for that matter, around the country. We know because before joining the court, she authored an ACLU brief arguing for abolition for the crime of rape. That eventually did come about in the Coker versus Georgia case. She was glad to see Maryland enact a moratorium on executions in 2001. She hoped the death penalty would one day be held unconstitutional because it could not be administered with an even hand. And finally, she famously declared in 2017 that if she were queen, there would be no death penalty. And the next slide, please, which makes me all the more happy that you chose this crowned Ruth as your logo for the entire exhibit, which has been, by the way, just wonderful. And we at OTSI just wish she had been able to carry out that directive, but instead it's up to individual citizens like ourselves to look to why and how and whether and hopefully when the death penalty will be repealed. Next slide, please. See, RBG, was a commoner in the sense that she couldn't direct it and she wasn't queen. And this quote always seemed to be suitable. It's on a shirt my sister gave me. Fight for the things you care about, but do it in a way that will lead others to join you. And I think that's her usual approach to things. Next slide, please. She was, as one person put it, a strategic gradualism. And as Newsweek or Time had put it when she was being nominated, she's a Frankfurter, i.e. Felix, not a hot dog, that she was going to be using judicial restraint as Frankfurter did. And she generally had. She chipped away by use of precedents, drawing respect and votes to her position. And on the death penalty cases, although she didn't write any of the eligibility ones that I mentioned before, she joined in those opinions to conclude that juveniles, intellectually disabled, and others shouldn't be executed. And she demanded accuracy and reliability in jury decision-making. In Schaefer versus South Carolina, jurors were not told that life without parole really meant life without parole. So the question of whether they should sentence to death or whether this person would be a future danger they were being misled by the jury instructions. And similarly, in Moore versus Texas, the intellectual disability exemption that I was mentioning has to be determined by science and by sociological, psychological associations, the professionals that deal with this, not Steinbeck's of mice and men descriptions of how intellectually disabled people behave. Gray versus Netherlands and Romano versus Oklahoma were both involving prejudicial information being given to the jury in ways that would mislead their ability to reach a reliable decision about the appropriateness of punishment. And she assured fair process and accountability in many of her opinions. Banks versus Stretke, in this case, the government had presented witnesses who perjured themselves during the trial, and the prosecutor was aware of that and did not disclose it, as he was obliged to do as it was happening, let alone for 20 years thereafter. In fact, he would have preferred if it stayed hidden all that time. The court reversed the death sentence in that case, saying the rule is not the government may hide and the defendant must seek. No, RBG pointed out it's the government's obligation to provide information that is exculpatory in nature, that is relevant to or could lead to a lessened punishment or a lessened or no conviction. So the Brady rule was upheld in that case. In Maples versus Thomas, this was a sad case. The lawyers who had been representing Maples were at a law firm, volunteer lawyers, because in many parts of the country, you don't get paid for these cases. And they had to go to another firm. They left that firm and did not notify their client or the court where his appeal was pending that they were no longer his counsel. And when the court sent notice of their opinion to counsel, they didn't follow up and send it to anyone. So Maples ended up missing the time deadline for filing a notice of appeal from that decision. And RBG put it well: abandoned by counsel and left unrepresented and unaware of a ruling necessitating filing a notice of appeal, no just system would lay the default at Maples' death cell door. He should be entitled to the appeal despite the fact that he didn't timely file. And I think those cases verify that you can't have truth without Ruth saying. She's really up there trying to maintain accountability and accuracy and reliability to the extent one possibly can in capital cases. Oftentimes it isn't possible, but to the extent one can try, she's working for that, and justice shalt thou pursue. The next slide, please. Gradually, though, she began to recognize the need to reconsider the death penalty's constitutionality, and she wasn't alone in that. Over the years, Justice Brennan, Marshall, Powell, Stevens, Blackmun have all decided that it's not worth tinkering with the death penalty and that it can't be done with the even hand and reliability that is required. And indeed, in an interview, she cited the wrongful conviction of death sentenced inmates. Now it's 185 have been wrongfully convicted and released from death row and from their incarceration because they were indeed innocent. There's considerable evidence that we've executed several people who were indeed innocent. The quality of representation available to death row prisoners, again, volunteer lawyers, underpaid lawyers, ineffective lawyers, untrained lawyers, lawyers who are unable to devote the time because every time they work the 700 hours you need in a capital case on average, you're turning away that amount of business from other cases that are probably well paying. The racial and geographic disparities in use of the death penalty troubled her a great deal. And she described the review of impending executions as a dreadful part of the business and as cases that still vexed and challenged her due to the law's density. And indeed, capital litigation is by far the most crazy, involved, and difficult litigation that one can undertake. So in 2011, she said that what she would most like to accomplish in the remaining years on the court was indeed getting a reconsideration of the constitutionality of the death penalty. And she was the only sitting justice to join Justice Breyer's dissent in 2014 decision respecting lethal injection. He went on to urge that they just reconsider the cases Gregg versus Georgia and the others that had upheld it in 1976. But we still have not done that. Next slide, please. Justice Breyer continues on the court today. You may have been hearing there's discussion about whether he might retire before the next session begins in October. He had clerked for Justice Goldberg, and he carries his efforts on and joined in all those decisions that limited death eligibility, but beyond that has been very concerned about the reliability of the punishment, citing convincing evidence that innocents have indeed been executed, the system being arbitrary, discriminatory, and geographically disparate, the lengthy delays that deprive the execution of serving the state's asserted purposes. And he's also been very much involved in looking at Evolving Standards of Decency and Cruel and Unusual Punishment Analysis from a whole world perspective. He urges that the laws and practices of other countries are relevant to the evolving standards of decency. Indeed, I don't know if you're aware, but the EU bars any one nation coming into the EU unless they've abolished the death penalty. And we've had multiple problems with the State Department trying to obtain extradition of individuals from many other countries around the world because we stand relatively alone in Western civilizations in having the death penalty. And these nations don't want to return individuals to us where that is the possible punishment. So he's been urging that we should take a more holistic, worldwide, if you will, view of what is cruel and unusual. Next slide, please. Justice Kagan is the most recent contributor to death penalty litigation, and she supported limits on eligibility and controls on discriminatory application that we'll talk about in a moment. But her opinions thus far in the area have focused on execution practice. One involving the competency to be executed, that someone has to have a rational understanding of the reasons why they're being executed. And if they are mentally ill and unable to do that, they cannot at that point be executed. Another case just this year involved the refusal to allow a Muslim death row inmate to have a spiritual advisor, an imam, in the death chamber with him when indeed a rabbi, a priest, or a minister would have been available under the Texas law. So this found that there was a clear denial of equal protection and denial of freedom of religion in foreclosing the possibility of having a Muslim minister or imam in the room at the time of the execution, assuming security protocols are followed. Next slide. I mentioned the court as being attentive to racial and ethnic bias, and I do want to mention this, that in the last couple of years, they have held that if there is a clear statement of stereotype or bias by a juror in the jury deliberations room, that you can impeach the jury verdict. In other words, inquire into that and determine whether or not the discriminatory comments may have influenced decision-making. And in Buck versus Davis, they agreed that an expert witness who testified to the stereotype that African-American defendants were more dangerous had received ineffective assistance of counsel. The defendant had, because he should have objected to that. So there has been an effort to try and weed out those instances where race and ethnicity may have influenced jury decision-making. But neither Justice Ginsburg nor Breyer will get their wish that the court overturn the death penalty on constitutional grounds with its present makeup that just is not foreseeable. So what we have is a continued use of the death penalty as a state decision now by the state legislature through repeal mechanisms, by the judiciary through findings of state constitutions being violated. State constitutions do generally have a cruel and unusual punishment type clause, and state courts have increasingly questioned whether and found that these provisions in their state constitution were violated by the death penalty in its operation, or executive branch decision-making to grant commutations or to foreclose any further executions. Next page, please. So what we see is a map here, and 11 states have abolished the death penalty since 2007, bringing it to 23 states that have now abolished altogether. In addition, 3 states have moratoriums. It's California, Oregon, and Pennsylvania. And really, you could add Ohio to that list, since Governor DeWine has indicated there'll be no executions until the method has been changed or the legislature comes up with the proper method that's upheld by appellate courts. Another 12 states have had no execution in the last 10 years. So it's really definitely on the decline. We've had a high of 300 plus people that were being sentenced to death in the early 90s. We're down to 18 or 20 last year. The system is falling apart and it's broken. And many states are abolishing, as I mentioned, and their reasons are ones that Ohio has in spades. Costliness and wasteful nature of this punishment. It costs up to $3 to $5 million per case. That's 2 to 5 times more than life without parole. And I know that many people may be suggesting this is about appeals, but it's not. From the moment the capital indictment is filed, there are additional costs. There's 2 counsel, there's 2 trials, there's experts, there's additional levels of disclosure. There's all kinds of additional expenses. And what we find is there's an immense amount of money being invested in this system in Ohio, and it's being wasted. I mean, I did a study of the 3,400 plus capital indictments that bring about these costs the moment the indictment is filed. And we've had exactly 1%, 1.6% to be exact, of those cases end in a death penalty. If we had a system that was failing to get what it was charged to be, 98% of the time, we wouldn't have that system anymore. And that's where we're at in Ohio. In addition, it's not deterring. In fact, if you look at the southern states where the death penalty is most frequently imposed, they have higher murder rates than the other states do without the death penalty. And every study has come to the conclusion, as the National Academy of Sciences pointed out, that there's no evidence that it deters. Retribution was the other suggested justification in the Gregg versus Georgia case, but we're increasingly aware that victims' family members don't want to have the death penalty. They don't want to have this wound reopened every 3 or 4 years when the case comes up and there's a question about whether or not there's going to be a death penalty upheld or not. They don't want to be waiting for 20 years to heal. This prolongs their pain and impairs their healing. And the money that we're spending on this is just outrageous. And where it could be better spent is on victim support services like grief counseling and vocational counseling, and efforts to solve cold case files that other victims' families never learned, who had been responsible or how or why their loved one had been killed. We've got ways to spend money that will be far better, and even the International Association of Chiefs of Police have agreed that funds that are devoted to the death penalty just are not doing what we would have hoped they would. So in addition to those problems, the wastefulness and the failure to achieve any benefits, it's not trustworthy. We've had 11 exonerations in Ohio. That's 11 people who were sentenced to death who were found later to be innocent. And in addition, I might add, each of those persons have been entitled to reimbursement from the state or have filed for and obtained judgments requiring that they be reimbursed. So there's millions and millions of dollars that are going to people that were deprived of their lives, many, not entirely, but significant portions of their lives. The average amount of time that individuals on death row, those 11, spent on death row in Ohio, or spent incarcerated in Ohio, was 20 years before the courts gave them relief. And we are really risking executing innocent people by continuing this practice. In fact, if you look at the statistics, we've executed 56 people under this 40-year-old law. We've had 11 exonerations. That means for every 5 executions, we've had 1 person who was innocent. To suggest that we're not going to make a mistake is ludicrous. In addition, it's racially and geographically disparate. In Ohio, racially wise, more than 70% of the people on Ohio's death row are there for a murder of a white person, even though more than half of all homicide victims are Black. Of the 140 inmates on Ohio's death row, more than half are people of color, even though they make up only 16% of our population in the state. In addition, data shows that 87% of those exonerees that we mentioned The black exonerees were victims of official misconduct, and only 67% of the white death row exonerees were subject to that. So we've got racially disparate results based on race of the victim. White victims' lives do seem to be mattering more. We've got racial disparities in the race of the defendant, with over 50% of the row people of color and 16% of the population. And we've got geographic disparity as well. Geographically, there are 5 counties in the state that make up 68% of death penalty cases. That's 5 of 88 counties are responsible for 68% of Ohio's death row. If it shouldn't depend upon which county you committed a crime in, but it does. The county prosecutor's personal views on whether death is something they want to pursue, the adequacy of defense counsel available to them, these shouldn't be mattering, but they do. It's geographic disparities like this that led the Ohio Supreme Court Task Force to advise that there be a statewide decision maker at the Attorney General's office with a committee of lawyers, prosecutors that would make decisions on a statewide basis. And that was heavily fought against by the Prosecuting Attorneys Association and has not been passed. So the geographic disparity issue remains and is another reason why we shouldn't be bothering to be doing this. Go on to the next slide, please. And Ohioans are knowing and understanding this increasingly. There was a poll conducted in the fall by the governor's regular polling service that found 59% of Ohioans, 59%, favor repeal of the death penalty and replacement of it with life without parole. And the reasons for that are all the reasons we've been discussing identified here. So on to the next slide, please. It's time for Ohioans to follow RBG's queenly direction. No death penalty, Ohio. To pursue justice as she would do, what should we be doing? Supporting the prospective repeal bills in SB 103 and HB 183. Those are the correct numbers. Sorry for the last time. Support those prospective repeal bills. They would preclude the death penalty being charged and prosecuted in the future. These bills do not deal with, as yet, the question of what to do with 140 people that are on death row. But that may be the subject of later legislation, of court decision, or governor's commutation power. Write, call, email your state senator and representative to support these bills. There will be hearings coming up in the fall, in September. We've already had proponent testimony in the state Senate. The companion bills mean these are designed to move quickly, and there is strong bipartisan support. Add your names to that. Contact Governor DeWine urging he support repeal. And go to the No Death Penalty Ohio website and take action, nodeathpenaltyoh.com. If we're all behind this, we can get RBG her wish and her queenly direction. And I encourage you to do so. Next slide, please. So No Death Penalty Ohio, that's where we could be looking. And I thank you very much for the opportunity to talk to you. I'll be happy to answer any questions. Emma?
Thank you so much, Marge. That was fantastic. I think I speak for everybody in the audience when I say that I feel like I have learned a lot. And so I do have a couple of questions from the audience, but before I begin asking you those, I just want to remind everybody who is here on Zoom with us now that if you have any questions for Marge, you can feel free to send them through the chat to all panelists. That's at the bottom of your screen, or also through the Q&A, and I'll be able to see your questions in either of those places. So Marge, first of all, we have a question from our audience about Justice Fortis. And so why was Abe Fortis on the court for such a short time? Could you tell us a little bit about that, please?
Yes, he replaced Justice Goldberg. In fact, there's a good deal of mystery at some points around why he left the court and succumbed to LBJ's entreaties to go to the UN. But it appears that LBJ wanted Abe Fortis on the court, and that this was the way to get him on. And he ended up coming off because there was controversy generated when he was nominated to be Chief Justice. And this led to some investigations that were never quite pulled together. But basically, he left under somewhat of a cloud that was not resolved. And he was by far the best lawyer in DC at the time when he was appointed, and he just decided it was best to go back to private practice.
Did he remain an attorney for the rest of his career?
Yes, I believe he did.
Thank you. So we just got a question in from Debbie in our audience that's talking about the Supreme Court today. And so I'm going to transition a little bit from the Supreme Court of yesterday into 2021. But so Debbie is wondering, what is your opinion on stacking the court? Or in other words, adding justices? I know that that's been a very talked about issue in the past few months.
Very controversial issue. The reason why it's possible to be done is that it's congressional enactment that set the number at 9. For many years in the early part of the Republic, there was no Supreme Court of 9 justices. I don't recall now, I think it might have been 5 or 6, 5 or 7, but the number was expanded by the Congress, and they had the ability to do the expansion. Now, when FDR tried to do that, it was political to get the New Deal passed, and those cases that had questioned the constitutionality of the New Deal to the point where he would like them to be. But that effort was not undertaken in the end. And I think that it's smart to put together the bipartisan commission that has been put together by President Biden to study this matter. There are some law professors who believe that their court has far too much to do and is unable to take as many cases as they need to resolve significant constitutional questions and issues of public concern that they don't have the ability to reach at this time. And the thought is that if there were more justices, they could have individual panels, perhaps. But there is some effort to do some of that court management at the circuit court level. Some people are suggesting delving more into the circuit courts and adding circuit courts and more people to the circuit courts to handle the resource problem. So I don't really have an opinion on it. I'm interested in seeing what the bipartisan commission comes up with as concerns and rationales.
Okay, thank you. That was a very thoughtful, thorough answer. And I'm going to spin off from that a little bit to ask one more thing about the Supreme Court of today. And so you mentioned in your answer that they're, excuse me, that they're a little bit overloaded, that there are just this huge variety of cases that require attention. So I'm wondering, do you know, should we expect to see the Supreme Court of today take on any cases related to the death penalty in the near future, or is that not something that we're seeing on their potential dockets?
There are cases on the death penalty on every year, issues that relate to capital punishment litigation. Basically, what ended up happening in 1976 was that in stating that you could have a constitutionally permissible framework, they set up a very, a couple of principles, 4 or 5 different principles that have been reaffirmed every time. But the teasing out of what those individual matters mean is, and how they apply in varying situations is subject of cases every year. And indeed, if the death penalty cases were removed, if we didn't have any death penalty in the US, I'm sure that the court would be happy from the standpoint of cases that vex and challenge them and that take their time because they want to do it right if they can, because a life is on the line. There would be a considerable sigh of relief. I know that's been the case in those states that have abolished the death penalty. The justices in those states are very happy not to be devoting sometimes 50% of their time to their death row cases. And that really deprives the rest of us of guidance from the courts on what is expected in other areas of the law, because they're delving so deeply into and needing to cover so greatly their death penalty docket.
I had no idea that that was the case.
Yeah.
I guess it
And
doesn't
in
surprise
fact,
me.
I'm sorry, but in Ohio, there was at one time the Court of Appeals review of cases in Ohio before they went to the Ohio Supreme Court. And sadly, the state referendum yielded a decision to take away the Court of Appeals review. So when a case is decided at the trial court level, it goes right to the Ohio Supreme Court. And they have no briefing, no help from other justices below them to separate the wheat from the chaff or give them guidance on researching the issues. They have to do all that work there. So it really takes away the opportunity to handle other cases.
Okay. Thank you for clarifying. That's really interesting.
Mm-hmm.
I'd like to pivot a little bit again. And so looking a little bit less at the Supreme Court today, but looking at some of the justices, the Jewish justices that you spoke about. In our audience, Joan is asking, other than justice shalt thou pursue, what other Torahic issues are cited? What about the concepts of people being created in the image of God and or cities of refuge? Do you see these ideas coming up in these justices' thinking?
They do. And in fact, there is some discussion of, as I pointed out, every one of us is more than the worst thing we ever did, that appreciating that none of us is God-like to that extent. We're making decisions, we're doing things that are not reflective of that perfection, and that we're still in the image of God, that you're destroying human life is part of the problem here. That you're adding more victims adding more victims' families, I might add, when we execute individuals. And we're doing some harm to correction officials, the trauma to them, as well as to jurors that have to hear these cases. There's been actually studies done about how damaging that can be. So the whole system has a perspective that doesn't really help see us as godlike creatures. From the standpoint of Judaic thought around the city of refuge idea, there was and is in the Torah and in the Talmud discussion of, if people can get to the city of refuge, then they can devote their lives to repenting and helping others in that city of refuge and be free from the punishment. But if they wander away from the city of refuge, they can be slain. And so there was an expectation of teshuvah, of forgiveness, of repentance, and an effort to provide that opportunity in these cities of refuge idea. And I like that idea. And if you think about it as the life imprisonment that we have as an option, that is far better. Everybody knows where the person is and they are not going to be a threat, then aren't we in a better position? And people can make contributions behind bars.
That makes me think a lot about just the idea of prison outreach and the idea that incarcerated people are changing their lives every day and thinking and growing, and that doesn't mean that we should give up on them.
Yeah, and that's the other part of it, that oftentimes the person that we're executing 20, 30 years later is not the person who did the crime. That a 19-year-old who was high on drugs who committed the crime is not the same person 30 years later incarcerated. Who, I mean, I co-counseled a case where the individual was better read than I am. I mean, reading much more dense stuff. We had wonderful conversations when we would go visit about his legal matters, because he had a brain that hadn't been used that day, that had been high on drugs, that he had actually started drinking beer out of a tap that his dad had when he was on his tricycle in the garage at 5. I mean, it's just, we're not the same person Sometimes that is indeed the case, and people do change. And there is an opportunity for that if we maintain life imprisonment type practice.
Thank you. I think we have time for only one last question tonight before we have to say goodnight and goodbye to everybody. But this is a really fun one, so I think you're gonna like it, Marge. Myra is asking, would you please share the endearing story about your son, Brian, and Justice Goldberg? So I think
we didn't get to that.
Before we say goodnight.
Oh, I love the fact that Myra asked that. Thank you, Myra. She was there that night. Justice Goldberg had dinner at our home the last night he was teaching in Akron, and he excused himself to help put our son, Brian, who was 9 years old, to bed. I didn't understand why at first, and then I recognized what it was. Brian had just gotten a shofar and had learned how to blow it, but he didn't blow it as well as he could with Justice Goldberg there. He was kind of nervous, and we had all said, Brian, play, and he was nervous. And so Justice Goldberg asked if he could come upstairs to help put Brian to bed, and saw the pennants on the walls and saw all the sports stuff, and asked Brian, do you know who the best hitter that ever lived was? And Brian guessed Babe Ruth, which I would have guessed too, but that was wrong. It was Ted Williams, said Justice Goldberg. And he said, do you know what that means? His batting average was .344. Do you understand what that means? That means that only once in every 3 times did he ever get a hit when he went to bat. So you can't be upset or disappointed or unhappy about not being able to play the shofar that well today. There'll be another time. And I sat there crying, and it still brings tears to my eyes, because he was that kind of person. He really cared. He really wanted people to be encouraged to continue to do their best at everything they could, everything they cared about. And he was a wonderful man.
What a wonderful story. Thank you for sharing that with all of us tonight.
You're
And
welcome.
so now that it's 5 o'clock, we're gonna have to bring our time together to a close, even though, Marge, there are so many more questions I could ask you about this topic. So thank you so much for taking the time today to help us all learn a little bit more deeply about the death penalty, Marge. And to those of you who tuned in through Zoom today, thank you for being here with us. We so appreciate your presence. This is the final program in the Scales of Justice series that the Maltz Museum has been running this summer, but we'll be hosting more programming around the notorious RBG exhibition through the end of August. And coming a few months after that, we'll be launching our upcoming special exhibition, Stories of Survival. If you enjoyed today's program, you can find out more information about upcoming programs and upcoming exhibitions on our website, www.maltzmuseum.org. Thank you again, Marge, and thank you to everybody in our audience for being here tonight. Have a wonderful evening.
Thank you. Enjoy.